I'll start. Assalamu alaikum everyone. My name is Mubariz Siddiqui. I am a lawyer who's been working in this space. Today, what I want to talk about is some of the common problems and some of the common, I think, mindsets that early stage founders should be aware of in order so that as and when their businesses grow and they're approaching venture capital or other forms of financing, they have the relevant legal and regulatory compliance in place. The first thing is the co-founder relationship, which is one of the most important things in any startup. This is one of the primary reasons why or one of the major reasons why most early stage companies fail is because there is some issue in this relationship. The most important aspect to understand about this relationship is that given that even in your early stages things are still so small, most people are very unlikely to go to court or go invoke any legal regulate or resolution mechanism. That's why, and even if you were to go to court, those processes are expensive, slow, and take forever for you to actually get any resolution out of it. That's why one of the key principles to understand is that trust is key. So whenever you're building that relationship or starting a business with someone, it's absolutely crucial for you to have that level of trust with them, number one. Then it's extremely crucial for that relationship to have the correct foundations. Now, that relationship can only have correct foundations if you put in the time that is required and clearly define and manage expectations. So if there is a person in that particular, say in a co-founding team who has a technical background, is obviously it's very clear they would take over technical side, and then there's someone with a business background would be taking over the management and operations side. Those things are easy. The more difficult thing is when those roles, or say more people, they're two technical founders, or say they're two management or operational founders, it's very hard to define roles then, and it's actually even more important to do it at that point. So when you're starting off, make sure you are very clear with each other around what it is that you're both looking to get out of this business or this venture that you're going to embark on, and what it is that both of you will be doing on a day-to-day basis. Obviously, startups are messy. It's not as clearly defined. The roles are not as clearly defined as one would like. It's not a big organization where you have your own set of like roles and boundaries. Most people have to do a lot of different things, but even in then, it's important to define what, or actually manage the expectations around who will do what. Last thing that I would want to say on this is that there are two main reasons why founders have disputes, right? And disputes are not bad. Disputes are fine. If both of you are agreeing on everything all the time, then one of you is not really useful, right? There has to be some sort of disputes in that regard. But it's about the nature of the dispute, and it's about how you manage and address the dispute that will determine your relationship going forward. So two major broad categories of disputes. One is around both founders wanting different things for the business. Now, if one founder thinks that the business should be a B2B, the other one thinks the business should be a B2C, then that's still, your market will correct you. That's a more like a कहाँ पे आपको ज़्यादा traction मिल रही है, कहाँ पे आप जा सकते हैं. Your investors will tell you. You'll see from where you're getting more interest, and that's something still solvable. If one thinks the strategy should be A, the other thinks strategy should be B, still solvable, and that's good, because that way you will be addressing like more actually debating the issues really well, and debating and considering all your options in depth. The bigger issue, which is very difficult to solve for, is when both founders want the same things for themselves. When multiple founders want to be the CEO, say multiple founders want to be the CTO, now that's a much harder thing to solve for. And that's where I would say those irreconcilable disputes happen. That overlap is not something that is very easy to address. So to sum it up, While your co-founding relationship, I would not advise you to get into some serious co-founder agreement or spending money on lawyers on something that you're just starting. You don't even know if this business works. You don't know if you will be around here a year later doing the same thing. What's important for you though is to record this understanding that you have कि कौन क्या करेगा, किसका क्या stake होगा, those things. Now, if not in a proper full-fledged legal document, it should just be an email where you say I will own X%, you will own Y%, and one more term that is very important for most founders to agree early on is around either vesting or what happens if one of them leaves or has to leave. And that's the most common dispute in a business that is slightly working. When there's some value being created and this one founder gets this opportunity, either which is a great job offer or either an opportunity to work somewhere else, what happens to their equity? The fairest thing to do is have a 4-year vesting when you guys start, and vest 25% each year, 25% of whatever you own. So if I own 10%, then 2.5% each year. And if I leave after 2 years, then I only get to retain 5%, and the remaining 5% goes back to the remaining shareholders. That's probably one of the fairest things. But still, put that down in an email. I've noticed a lot of people are not dishonest. People are not out there to cheat their co-founders. People genuinely, truly believe that the agreement was for something else, or they genuinely believe कि नहीं मैंने 35 नहीं मैंने 30% बोला था. So it's very important to record these things so that you do not have any major issues going forward. Okay, so this is not working. Okay, yeah. Now, forms of business organization. Before we get into the different types of organization that you can register, whether it's a company, it's a partnership, etc., there are two key concepts that you need to understand. One is separate legal entity and the other is limited liability. Separate legal entity means that the organization that you will create, your business organization, it will be a separate person in the eyes of the law. तो वो एक सेपरेट समझे एक इंसान है कानून की नज़र में, obviously not capable of death, but you can liquidate it. But that separate legal entity is capable of owning things, it's capable of owning IP, it is capable of entering into contract with people, it is capable of employing people, it is capable of owning property, etc., etc. Limited liability, of course, comes with separate legal entity. Limited liability means that the people who own the organization, their liability is limited to whatever they've put into the organization. I will come to that concept again after going through the types of organization. Broadly, there are 3 types that you should be aware of. There is sole proprietorship, partnership, and private limited company. Sole proprietorship and partnership are not separate legal entities. It is essentially, if it's a sole proprietorship, it's the person who is working in their individual capacity. That's the sole proprietor. So, if proprietorship enters into a contract with the person, then what that means is, then it's that proprietorship का जो owner है, the proprietor जो है, it's that person entering into a contract. So if Mubariz Siddiqui is operating as a legal counsel in his independent capacity, then if I employ people, then I am liable to pay their salary. If I'm giving legal advice, then I'm liable to be sued if the advice is not right, etc., etc. Partnership is like a sole proprietorship. It's not a separate legal entity, but it's when multiple people are doing the business together. All partners are liable in that situation. It's not just limited to say one, it's not a separate entity. It's that agar, for example, you go and take a loan from a bank and the partnership fails to repay the loan, every single partner is liable to repay it, either jointly or severally. So agar do partner bhag gaye aur aakhir mein ek reh gaya, then the entire loan is going to be repaid by that one partner. Lastly, a limited liability company, which is a private limited company, is the most common form. Private limited company is actually a separate legal entity. You own it and control it by virtue of owning shares in it. And when you own shares in it, you can appoint directors. The board of directors is what runs the company. They make the decisions on a regular basis. Operational decisions on a daily basis are made by the CEO and the team below it, but the board of directors are the ones who actually call the shots in the company. Now, Limited liability in this context, let me explain the difference between a private limited and the sole proprietorship and partnership. So both, say a partnership has three partners, 33% each. Say a separate private limited company has three shareholders, all own 33% shareholding each. Both take 1 crore rupees from a bank as a loan, or say from an individual as a loan. Both default on it. Now, the partnership means that all three partners are liable. So, if the partnership's assets, जो भी उनके पास है, for example, एक office था जिसमें सोफे, कुर्सियां वगैरह सब कुछ था, if you cannot repay the loan with that, the partners would be liable individually. So, sell your laptop, car, whatever it is to pay the loan back, you would be liable. In a private limited company, your liability is limited. So, the shareholders, for example, each put in 10 lakh rupees each into the company. The company's assets are worth 3 million, but the loan was for 1 crore 10 million. So what would happen then is that the creditor would be able to take over the assets of the company, the 3 million worth, but the remaining 7 million would not be recoverable from the shareholders because their liability is limited and the company is a separate legal entity. Now, of course, banks would want to take individual guarantee, etc., but that's a different thing. Think of this in terms of liability that comes up if, say, you are in a business that could be exposed to, say, you are giving health related advice online, and turns out that your advice is wrong and someone sues you for it, for negligence or whatever, and you're liable to pay that person money. In that situation, a private limited company would be, the liability of the shareholders would be limited to whatever the assets of the company are, but partnership and sole proprietorship, the actual proprietor or the partner would be liable. Now, what form of entity should a particular startup go for? Startup should start with either a sole proprietorship or a partnership while you are trying to validate your hypothesis. Just coming to questions, right? While you're trying to validate your thesis कि ये जो मैं करने जा रहा हूँ या मैं आप MVP जब बना रहे हो उस वक्त तक try to keep it as simple as possible without having to spend money on lawyers or any form of legal organization. Once you're ready to either get bigger, where you're taking on partners on board, or by partners I mean whether an investor is coming on board or whether you're taking some sort of financing, whether equity or debt, at that point, I would say you could still go for incorporating a private limited company. There's no ways anyone's going to give you equity investment without you incorporating a private limited company. Maybe friends and family could give you a loan or say some paise वैसे कि आप शुरू कर दें, but and in terms of a proper investment for which they're going to take shares, it has to be a limited liability company, a private limited company most likely. Yeah, you had a question. Yeah. Yeah, I mean, the only challenge with that is that just recognize what it is that you would want to be very soon. So say if I'm a startup just starting today and I know that I will be going for VC funding at one point or the other, at that point I would rather just stick to a much simpler way, a partnership which is easier than an LLC to incorporate. It takes, all you have to do is sign a partnership agreement and then you can go open a bank account, get registered by the Registrar of Partnerships. That's another simple step, as opposed to opening an LLC and then transferring and converting it into a private limited company. You might just have that LLP for like 4 months, 5 months. इससे अच्छा उस टाइम तक आप लोग एक लूज पार्टनरशिप करके बैंक अकाउंट खोल के काम शुरू कर सकते हैं to convert that. So LLP is typically for organizations that want to stay in LLP for a while, right? So if it's a law firm, chartered accountants, etc., it works better for them. But if you're going to be a company that will raise substantial amounts of financing, that is looking to eventually exit either in an IPO or through an acquisition, then a private limited company makes more sense. Do you guys have any more questions? That's done? Oh, okay. So this aspect is covered. So if you have questions, we can discuss questions around this right now, and then I move on to other aspects. Okay. Now, given that you're just starting off, and I do not expect any one of you to have a head of legal or head of compliance on board, which would be an absolute waste at this point, depending on what you are. One framework that really helps, I think, early versus a lifestyle business is that the institution is not dependent on that one person to operate forever. Uh, to be honest, the way you make a real company is by, or a real business institution is by being able to remove that one person after 4 5 years, 6 years, 7 years, and the business would still keep running. Like, for example, Bezos has just left Amazon. Fine, not the best example is after 2 decades, but still, it's a company that can work without him. It could work without him long time ago. The reason why it's the difference again is between a lifestyle business and institution is that institution has kept all the record and has kept all and everything, all the decisions and all the systems are in place to make sure that agar aaj is CEO की जगह कोई और भी आ जाए, they would know how to operate this company or this business and how to grow this business, because everything is available. Now, how do you create, and I'm going to restrict myself to the legal and compliance aspect, but that's one of the more important aspects for your for an institution. How do you make sure that from day one you're thinking about building an institution and not a lifestyle business that is heavily dependent on you? It's a 3-step framework. सबसे पहले evaluate all existing relationships that you have with the stakeholders. Number 2, identify all applicable documents or laws where those relationships would be recorded. Lastly, whenever you're making a decision, make sure you review all of those documents, or make sure you review wherever those restrictions or obligations are recorded. Okay, so evaluate. In the middle is your company, okay, that little 2 boxes. Every single relationship that company has with someone, okay, it has that. So, for example, the regulator bit. Say you are a private limited company. You're required to regularly do some filings. Every time you change a director, you have to tell the SECP. Every time you're doing, say, changing the nature of your business, you have to take permission from them. Anyway, we can get into that separately. Similarly, the minute you exist, you have a relationship with FBR. They want to tax you whenever you make money. Now, if you go on, let's move above, if you go on to borrow money from a lender, you automatically have a relationship with the lender. That relationship will be captured where? In your loan agreement. Similarly, shareholders, your company's constituting documents such as your articles of association, etc., already capture your relationship with the shareholders. Uske alawa, mostly whenever people get and take on an investment, that investment is recorded in a shareholders agreement. So that's another document that records that. Similarly, there's vendors, their employees, their partners, their customers. Every single relationship that this company enters into is recorded somewhere. And what this little model or exercise will help you do, it'll take you literally 20 minutes to do this. Sit there with a piece of paper and a pen, and you can just draw this out for your own particular business. Every single one of these relationships is recorded somewhere. And that's our, that's our step number 2. You make an Excel sheet or a little table and identify, number 1, which party it is. Number 2 column is which documents govern my relationship with this party. So if it's an investor, it's a shareholders agreement, it's the Companies Act, it's the Memorandum and Articles of Association. All these 3 documents would and just fill them out. It's very simple. Shareholders agreement में reserve matters लिखे हुए, reserve matters में है कि मैं फलानी चीज़ investor की मर्जी के बगैर नहीं कर सकता, etc. etc. Then there's transfer restrictions के I have a vesting schedule. The investor said I cannot transfer my shares without before a certain time has passed, etc. इसी तरह investors के बाद you have lenders, you have customers. Customer ki typically aapki और customer ki relationship, if you're a complete tech product or say the interface is entirely digital, it will be your terms and conditions or your privacy policy, etc. would determine your relationship with your customers. इसी तरह करके you will realize that you have a pretty good understanding of who you owe an obligation to or who you have a right against. Say if you are a vendor for someone or a customer, you have a right to receive payment from them, presumably. I hope you're selling something for money. And if they would have, and you would have an obligation to deliver the product or the service that you agreed to instead of that money. So essentially, all relationships would have a set of rights and a set of obligations. The more aware you are, the more likely you are to not breach those set of rights or obligations that you have, right? And as you breach, say, an obligation that you owe to a customer, that would result in can result in anything from a disgruntled Facebook message or a public announcement on Twitter to a lawsuit, depending on the nature or the size of the service or the product you're providing. Lastly, every single time you're making a big decision or you're entering into a transaction, just go through and review कि कहीं कोई regulatory obligation तो नहीं है, कोई किसी shareholder से तो वो नहीं है, किसी और contract में तो ये चीज़ मुझे नहीं stop कर रही है करने से. And at the end of the day, you'll realize that most of the decisions that you make will be somehow compliant. Because there would be those red flags going off in your head before you could, while you are making those big decisions. Anyway, any question on this front? Yeah, sure.
I'm a startup here. I'm aware of everything that we discussed. There is no boilerplate sort of agreements for, like you said, you're aware of the simple startup. Where would you go from resources? Because majority of the time, you don't need you see the developer, right? So is there a database or is there a repository where we can tap into? Or and I see might have that startups can tap into.
So you can't have boilerplate templates for literally all different kinds of businesses, right? So if you're, say, a SaaS business, you'd have a completely different contract as opposed to an e-commerce business. And then contract with whom? Your customer, your vendor, your employee.
Agreements are your bespoke agreements, but the three sort of company setup that you discussed, regulatory work, things, the partners, whatever you can, whatever resource you can. The reason for the question is because a lot of startups come in IC, and there are muchness, right? So the SaaS business will always be SaaS business. So if there's a resource repository that we can tap into, that will make life a lot easier.
No, that would obviously be very helpful. No, I completely agree. That would be very helpful. At one point, I did try to solve for that as well. The challenges that I encountered at that point were more around the fact that in order for something to be standard or something that most people would consider as a boilerplate and go for, that industry needs to be a bit more robust and like, those transactions need to be more frequent. Now, there are not a lot of SaaS providers in Pakistan. Very few. Most of the SaaS that Pakistanis consume or SaaS services that Pakistanis avail are from abroad. And let's be honest, no one even opens the terms and conditions ever. So that's just the fact of the matter, right? So the boilerplates, what I typically see founders, what they do is they pick out the say if I am doing something that's very similar to Spotify, I would go pick out the Spotify terms and conditions, I would pick out the privacy policy, and I would just adapt them to Pakistan. Go to a friend who's a lawyer and adapt them to Pakistan. For these boilerplates to exist for all these different kind of services, I still think we would need these to be more common so that at least there are more common ground rules set. And even the founders would need to have that kind of understanding of what their business is for them to exist. But yeah, it's something that I would want to see exist in this world, for sure.
So, just fair warning, at least half the startups.
Oh, half this. I never expected to go to an incubation center and just be filled with lawyers. But that's good. नहीं उन दोनों को तो मैं जानता हूँ जी. हाँ नहीं नहीं बस मुझे इतना तो पता है. But okay. Any other questions? Okay. Now, just an overview of how you should think about fundraising. And this is something that comes up fairly often in most of my conversations with startups, and not really lawyers, but startups, people who want to go and build a venture which involves raising capital. Now, there are broadly two different kinds of capital you can raise. One is equity, the other is debt. Debt is a loan. इट मीन्स कि मैं आपसे आज पैसे लूँगा और मैं आपको एक टाइम पीरियड के बाद वो पैसे वापस कर दूंगा. जब वो उस टाइम पीरियड में मैं आपको इंटरेस्ट दूंगा उस डेट के ऊपर. इट्स रियली दैट सिंपल. द डेट प्रोवाइडर obviously typically wants some sort of security because that debt provider is not taking that big of a risk with you. So what they're saying is कि सही है, मैं आपसे अगर मैं 1 करोड़ रुपए लैंड कर रहा हूँ तो मुझे कोई सिक्योरिटी चाहिए. या तो आपके पास एसेट्स हो 1 करोड़ रुपए के, जिस तरह हमने पिछली एग्जांपल दी थी, बिकॉज बैंक्स एंड ऑल वुड नीड सम सॉर्ट ऑफ. या तो आपके पास कोई इस तरह की कोई चीज़ हो कि अगर आप नहीं दे सके मैं उस चीज़ को लिक्विडेट करके अपने 1 करोड़ रुपए वापस ले सकूँ प्लस इंटरेस्ट. When you're starting off, it's very difficult to access debt because you do not have that collateral, you do not have a business, you don't even have a validated model. So what you typically go for at that stage is equity. Now, equity pretty much means someone is putting money in your business and is not asking for that money back. They're taking a risk with you in that business. They're saying, okay, if this business were, instead of this money, give me this percentage of your business, of your entity. If this business works and it's worth a lot of money, then my percentage would also be worth a lot of money that one day, is the bet. And when we talk about VC investment, we primarily talk about equity investment. Obviously, there are hybrid notes like convertible notes which come in as loan, but then they convert into equity based on certain milestones or certain events happening. Now, when I see a lot of startup founders want to go raise equity, and one thing that I see as the most common thing missing from their pitch is the fact that they cannot very clearly communicate what they need the money for. Okay, just always remember, finance or capital is a means to an end. It is not the end. The purpose of starting a business is not to raise money. The purpose of starting a business is to create value and then capture that value, and then hopefully when you capture the value you would make a lot of money, or build an organization or institution that would be a machine that keeps creating and capturing value. In order to understand how to communicate this aspect around why you need that money, what outcome would that money help you achieve, I like the framework that Mark Andreessen puts, which is the onion theory of risk. I talk about it pretty much every single time a session like this because I think it's a very simple way of understanding how to be approaching capital. When a business just starts, it is an extremely risky proposition. Why? Why is the business at its earliest stage the riskiest as opposed to a business that is listed on the stock exchange? Because at its earliest stage, there's probably not even a business. There's a lot of assumptions, and there's the ख्वाब भी है, थोड़ी assumptions भी है, and obviously there's a determination and all, but a lot can go wrong. Everything that can go wrong is a set of risk, right? Or is a type of risk. So for example, when a business starts, let's say a market risk is this. Whether I say, for example, I want to sell make these remotes locally, these presentation clickers locally and sell them. Now, my first risk is whether a market exists for Pakistani local made remotes or not, these clickers, these presentation clickers or not. Second risk that exists, is there sufficient competition? Can't people just get these cheaper from China or get them from somewhere else? Then the technology risk, can a product like this be built to begin with? So if you are doing a biotech type of company, or say a deep AI type of company with artificial or heavy technical aspect on it, there'll always be a technology risk कि ये हम बना भी सकते हैं या नहीं बना सकते. Then again, there are layers and layers of risk, and that's why it's called the onion theory of risk. As your business grows, you keep peeling off a layer of risk. You raise capital to peel off one or multiple layers of risk. So the seed round or the angel में जो बिल्कुल शुरू में आपका जो लोग काफ़ी लोग प्री सीड भी कहते हैं ऐसे round is, can I make a minimum viable product to validate my hypothesis, which is that someone would be willing to pay for whatever it is that I'm building. Okay, that's the first layer of risk, which says कि okay fine, इसकी आप ये वाली चीज कोई ना कोई इसको valuable consider करेगा. Then there are all those risks around whether I can grow it, whether I have the capability of building a team around it, whether I will be able to distribute it, etc., etc., etc. That's what the onion theory of risk is. So whenever you're going to raise capital or raise funding, what you need to make sure is that you can communicate very clearly why you need this money and how will this capital allow you or enable you to de-risk your business. That's pretty much it. That's my that's my presentation. But yeah, anyway, do you guys have any questions around anything that I've said so far? Yeah, sure.
Started sole proprietorship or partnership with their
Yeah.
What do you think is the right for startups that are trying to bootstrap and scale organically instead of raising capital from outside?
You're asking, so your question is, what is the right form of business organization for a startup that's trying to bootstrap and does not want to raise any external funding?
Yeah, like you mentioned a sort of a transition going from sole proprietorship or partnership to incorporation.
Yeah.
How do you think it would be different for businesses that are trying to that are intending to bootstrap and then scale organically?
So you open a limited liability entity or go towards that end if you want to limit your liability, because either you're doing something that is capable of exposing your business to some sort of liability. So either health tech or say handling anything that could result in that kind of liability. Or to create a separate legal entity. Now, if you're not raising funding, you may not want to do a private limited company, right? Or if you're not being exposed to serious liability, you might want to stick to a sole proprietorship or a partnership because number one, it's easier from a compliance perspective. It's easier to start off with. Your tax is actually lower if you are a partnership or a sole proprietor, as opposed to, depending on how much money you make, but as opposed to a private limited company. So those are the considerations. Now, you need to decide if you have co-founders and eventually what you want. अच्छा, partnership का मसला ये है कि partnership ends with the death of a partner. And whenever you're dealing with human beings, one real risk that always exists is death or injury or incapacitation, etc. A private limited company ensures कि जो company वैसी ही रहेगी because it's a separate legal entity. It will ensure that that person or that partner, their share in the business would be represented through each individual share, and that shareholding that can be managed through a shareholders agreement. So to have an organization that would be in perpetuity, regardless of people coming and going, then you need a company. But if you're doing a business where you are making cash without needing a private limited company, then I would stick to a partnership, or because it makes life easier. There are other tax issues around this as well, right? Okay, private limited company, every single time it has to make payment to a vendor, it does not have to deduct tax at source. There's no withholding tax. Oh, private limited company has to deduct tax at source, withholding tax hota hai. But partnership को या sole proprietor कोई tax withhold नहीं करना होता source पे, unless partnership is above a certain amount, which is around like I think 500 million rupees a year in revenue or something like that. So yeah, so there are those technical benefits of not opening a private limited company. Problem? Yeah. वो एक मिनट mic आ जाओ. या इनको mic दे दीजिए.
You mentioned that
one should know the reasons for raising capital, not just for the sake of it. One of the reasons of raising capital includes salaries for staff. What about the founders? Have you seen that founders also taking salary, and that is considered a viable, a reasonable requirement while raising capital?
Yeah, of course. See, salaries for how long and how much, right? They're two important. Like this, those are two variables in this. If I go and say कि हमें 2 साल के operations के लिए पैसे raise करने हैं, that does not mean anything, right? It could be a failing business which is paying salaries to employees and its founders for 2 years, whereas it making no revenue, whatever. When you try to raise capital, what you say is कि I need say $1 million to achieve these objectives for the business. Now, those objectives are that whatever your primary or secondary metrics are by which you measure the success of the business, are typically ARR. So, जी मेरा revenue अभी $5 lakh है, but अगर मैं ये पैसे raise करूँगा, I can take my revenue up to $3 lakh. $3 million. Now, the question is, अच्छा revenue $3 million को raise करने के लिए क्या करना पड़ेगा? जी मुझे अपनी सेल्स टीम को एक्सपैंड करना पड़ेगा, मुझे अपनी मार्केटिंग एफर्ट्स को एक्सपैंड करना पड़ेगा, एटसेट्रा एटसेट्रा. So obviously, so you explain it that way. But again, the purpose by which you're raising that 1 million is not the salary. It's to achieve that objective. To achieve that objective, you need more people, and to get people and retain people, you need to pay the salary. So it's that way. Most founders, when they're pitching for investment, what they end up saying is कि हमें जी 2 साल का runway चाहिए, हमें 18 महीने का runway चाहिए. Runway means nothing. It's useless if the business is not going to work, and if this capital is not going to help move the actual KPIs of the performance of the business. Doesn't matter कितना runway है.
But yes,
So
when you make all the projections and KPI plan, and you make the cash flows, within that cash flow, the founder's salary is legitimate.
it's definitely legitimate. Now, what should the founder salary be based on? That's the other question, right? The founder now. Why is venture capital, even if it's say a business on a pitch deck, why is the valuation so high? And why is a VC taking a small chunk? The VC is taking a minority shareholding, and that's the entire model. The minority shareholding is being taken because they believe that if they take a bigger chunk of the shareholding, the founders would not be incentivized to continue. To incentivize the founders, the investor is taking a smaller chunk कि हम आहिस्ता आहिस्ता और फंडिंग रेज करेंगे तो आप डाइल्यूट होंगे, तो हम चाहते हैं कि 7 साल बाद भी आपके पास सब्सटैंशियल चंक बचे. Now, keeping that in mind, and keeping the fact in mind that the founder's biggest incentive is the equity, कि जब ये equity एक दिन बढ़ेगी, and that's where the money is going to be made. The founders will be paid a salary, of course, because they need to run their house, but not to ensure that their market salary is being captured, not to ensure that they are living that lavish life, but to ensure that they're comfortable to the point where they do not have to worry about another source of income कि यार इस महीने स्कूल की फी नहीं भर पाया इस महीने. So अगर वो that would be the objective in anything कि यार इतने तो minimum पैसे देने, otherwise this person cannot give their all. So that kind of salary.
That, if we are government of Pakistan is giving certain incentives for startups, like tax-free for the next 5 years, I think that it was last year. So in that case, to avail that, initially it's always a burnout without any profit for at least a couple of years in most of the cases. So how do you benefit from that? Do you get registered into that system once you start making money, or do you have to get into that system as soon as you start the business and lose the 2 years of loss?
So even the exemption is not कि आप जिस दिन से register करेंगे उस दिन से time शुरू होगा. It's for first 5 years of your existence. So whether you register 2 years later, they'll only give you for 3 more years. That's why that exemption was not successful, or does not mean much, because most startups are not making an income. They would whenever they make excess cash, they would reinvest in the business for growth anyway. So that does not mean anything. In a startup, the idea is, or at least for the founders or the early stage investors, is that their incentive is entirely on capital gain and not on dividend. So they want कि शेयर की कीमत इतनी बढ़ जाए कि वैल्यूबल हो जाए कि हम जब अपना शेयर बेचें हम उससे पैसे कमाएं, एज अपोज टू द फैक्ट कि स्टार्टअप इतना प्रॉफिट बनाए कि वो हर शेयर होल्डर को डिविडेंड दे. Obviously, if you have a higher profit, the value of the share also goes up, but the value of the share could go up based on other factors as well, such as the opportunity, the speed at which you're growing, the size of the market, and say the potential that people see in the founders. So उस tax exemption से कोई खास फायदा तो है नहीं. आप at any point in your time you can go and try to register for it, but they will count it from the time you come into existence.
If you started a company, not at a profit initially, and after 3 years or 4 years or 5 years, I buy it out from you. And for me now it's a new company.
No, the FBR will see that it existed from before. Okay. So, I mean, they will look at, you can try to get around it one way or the other, but if it's not entirely legal. So, yeah.
Thank you.
No problem. The two people, yeah.
Are they doing anything about it? Are they going to change or they have not?
No, they have started the ST Special Technology Zone में जो companies होंगी उनको अब 10 साल का dividend पे, income पे और capital gains पे tax का वो 10 years का दे रहे हैं. That would be helpful.
But then you have to shift into that building, whichever zone.
अब वो zones हर जगह बनाने की बात कर रहे हैं. So you would have to have some sort of office presence there, definitely.
Okay.
जी जी.
Thank you, Mubariz and Nasim for the session. Okay, my specific question is about the holdco companies.
जी.
I don't know if you're talking about that in your presentation or not. So when we are going for funding, तो ये अभी जो नया holdco का आया statement है, you have a private limited company है, पहले आपको ये बनानी है या पहले आपको holdco बनानी है?
पहले
private limited company बनानी है, फिर आपको यहाँ से वो पैसे ट्रांसफर करने हैं, which you talk about on your Twitter. मुझे उसका थोड़ा सा बता दें कि वो क्या process है.
The process is basically you first make a private limited company here, then you make a holding company abroad, but you can only open a holding company if you're bringing money inside Pakistan. You have a foreign investor who's willing to invest in Pakistan. You open a holding company abroad, then you transfer in the same shareholding as a private limited company here. Then you transfer all your shares in this company into the holding company, and then you register it with the State Bank. This is how the sequencing would work.
Okay, so your co-founder and you, say for example, you have two founders. First, you have to transfer your shares in the holding company wherever you are operating, like Delaware or wherever. उसके बाद फिर आपका इन्वेस्टर उसमें शेयर्स होल्ड करेगा.
बिल्कुल.
और फिर वो ट्रांसफर होंगे यहाँ पे.
बिल्कुल.
सही है. ओके, और ये इसमें टैक्सेशन का कुछ आप बता सकते हैं?
इन्वेस्टमेंट पे टैक्स नहीं है. टैक्स होता है इनकम पे. So this is someone investing in the business to get shares in the business. So they will not be taxing anyone. So there's no tax element in this.
Okay. Thank you.
No problem.
Just want to ask, what's the regulator's view on raising funds via crowdfunding?
Via crowdfunding?
Yeah, and if they're going to make, I think it's illegal, but are they working on that?
No, I think in SECP's in their sandbox before this one, that's just say pehle wale mein, there was a crowdfunding platform that has come up. I don't know how far and long they are, but clearly the regulator is looking to allow for that. I am generally a bit skeptical of crowdfunding for the risk that it holds. Startups and early stage businesses are extremely risky propositions. Literally, a founder could do something which could completely derail the entire business as well, and we've seen examples of that in Pakistan. Raising money from public for a startup for me is a very risky thing. I would rather go to institutional investors or angels who actually understand the kind of risk that is involved and who are then undertaking that risk based on their own assessment and their own judgment. The regulator is obviously for these reasons very cautious, but they are allowing for it. I don't know how far that platform is though.
Just a comment with that. Are you not undermining or underestimating the investor as a public investor? Because there's a lot of money slushing around in Pakistan.
I'm not underestimating them. What I'm saying is that, okay, in Pakistan, startup investment is fairly new. What I'm undermining is the ability of most public investors who are used to investing in either capital markets or public markets or safer or more de-risk investment propositions into businesses that would be run by startup founders for minority positions with no proper governance around, right? So invest in a, okay, for example, a private limited company raises $300,000 from the public. Who is keeping an eye on the founders not taking out a Mercedes as the company car for the CEO? Right? I know that if it was a private venture capital fund, there would be reserve matters on how you would spend that money. There would be governance. There would be background checks and everything. In this situation, I can see, or say just a very, say if it's not a blatant fraud like this, say just a very poor analysis of what the market is, how globally similar companies have worked, and etc. So there is that risk. While I do think people should be allowed to invest in private companies on a more public level, private companies should be able to raise money from the public, but at a more de-risked stage, not early on. And not at a very small scale. So if the company is above, say, has gone through a certain threshold, has proved itself out, then sure. But it is a regulator's job to ensure that these kind of checks are in place whenever these companies are going to raise.
You can mention the gem.
Yeah, now, so that's what's happening with PSX is that they're allowing for smaller companies to come on and be listed on the PSX's GEM board to be able to raise capital from the public. They have those stringent regulations. They have how much you can price your share at, how much money you can raise, what the valuations are. I don't see a whole lot of startups being able to benefit from that, but maybe later on in their journey.
Just on that, the PSX bit, who is doing the DD on that? So if you're taking DD on your crowdfunding platform, someone who is doing the DD on the.
I mean, when you have bookmakers, when you put it on the PSX, there are regulations around how much you can price your shares. Your shares can, number one, your company has to be in existence for a certain minimum amount of time, 3 years at least, and I think it's 5 to 7 years for the 5 years for the main board, 3 years at least. That means you have 3 years of audited statements. You have 3 years. Your share pricing can only be done based on a certain number, like your other metrics, which are again coming from audited statements, and so there is governance in place, right?
The limits are being defined by the GEM board itself.
And then उसके बाद दूसरी बात यह है कि उसके बाद once a company is on the board, then it has all sorts of compliance that they have to do. Everything they have to make things more public. It becomes a public company. As opposed to a private company which can go ahead and do things the way it wants, and that's the flexibility private companies need. So yeah, I would say once a private company is de-risked to a certain point, then sure, and we still haven't figured that out here. But overall, for super early stage, less than 3 years even, crowdfunding, I would say, is a fairly risky proposition.
Thank you. Just a question, first question about limited liability. So, like, what are the cases, like, is it like defined somewhere, or like, have there been like cases where, lifting the veil you?
होते हैं. Obviously, there's Pakistan law around lifting the veil of incorporation, which basically means that the court would say that the liability is no longer limited and each shareholder is liable. It typically happens where there's a shareholder who owns a very big chunk of the company. It happens when the liability or the way it was structured, the entire transaction was where the guy was personally liable. But it doesn't really matter for startups as much because if you're going to be raising debt from a bank or an institution, they would want to get your personal guarantee anyway. So there would be no need to lift the veil. But if I'm a single member company that's running an operation and the company does some sort of fraud, or say the company does some sort of activity which results in a huge liability, then I'm pretty sure they would be lifting the veil. If not, most crimes around or criminal laws around holds the directors and the CEO responsible anyway.
Right. They were talking about Origo, but like in the case, if a local Pakistani tax management wants to own like more than 20% of a foreign entity, how like is something getting better on that side?
So the holdco setup is for more than 20%. If you want to own less than 20, if you want to own 20% or less, then you can directly get sweat equity.
What if money is not even coming in Pakistan? It doesn't have to come in Pakistan.
And if you want to own more than, then you have to go to State Bank for a special approval.
Right. So if you own more percentage than that, and neither money is coming in or your customers are here.
No operations are here, you have to go to State Bank for specific approval. I mean, okay, no, it's live. But if you just go and own it, who's gonna know? But no, you should go to State Bank and get specific approval.
So my question is regarding event financing. So in a lot of startups, we see that there's a founding team where there's co-founders with a high percentage in the equity, and then there's minority shareholders as well. During your presentation, you mentioned that let's say you raise debt and then, for example, two of the partners run away, and then the partner that's left behind will have to eventually pay back. So how do the risks for minority shareholders turn out when?
So that only applies if you have a partnership. In a partnership, all partners are jointly and severally liable. So which basically means कि सबके पास पूरी responsibility है, या तो उन सब में split होगी, अगर दो partner चले गए तो एक में होगा. In a company, it's just the company that's liable. So shareholders on an individual level are not personally liable anyway. And that's how it's done in a company. So that problem doesn't exist if you have a private limited company. So in a partnership, you will not have minority shareholders. You will either have a partner or not a partner. So वो वाला.
How do these Delaware companies work? How are people just like owning them?
What do you mean? How are they owning them?
I mean, like you said, you can't just like they own like what we just talked about. So, like with these Delaware or like private-based like companies, like how is that happening?
So typically, if I say today buy shares in Apple through Robinhood, no one will know, right? No one would have. People are declaring it in their tax returns, but that's not being shared with State Bank. We do not have that central sharing database. The cases where everyone gets stuck is where you have a holdco abroad and you have an operating company in Pakistan. When the holdco owns the operating company, you go to register the shares of the operating company in the name of the holdco to State Bank. That's when State Bank wants to know who all owns the holdco. And if they see Pakistanis there, then by law they have to stop it. And that's how most holdcos encounter friction. But if a Pakistani sitting here today owns shares in Microsoft or Apple, etc., no one knows, right? And nobody ever finds out, because that's the nature of these companies. Now, if the founder is not a Pakistan tax resident, they can easily set up companies outside of Pakistan. It's not an issue. Some founders who are Pakistan tax residents do intend on moving there, and that's why they typically own them. Otherwise, some are doing it out of ignorance because they don't know that this is a restriction on them. Yeah, it's usually broadly falls within these three cases.
Sorry, थोड़ा follow up basically the whole book. So थोड़ा सा explain कर देंगे कि जो आपने भी कहा State Bank, you have to go through State Bank. So मतलब point with desk है वो क्या है, you have
No.
you have your bank on the.
So after you have set up your holdco, after you have set up, obviously वो सारे shares हो गए, investment आ गई आपने पाकिस्तान में.
Sorry. First you have to send remittance for setting up the holdco from here.
उस पे $10,000 की वो है. So you go to your bank, the bank will allow you to send those $10,000
So you
abroad.
have to go to state bank or to bank?
Bank. You cannot speak to state bank. You
Okay.
can only speak to your bank, and your bank will go to state bank.
Okay.
So the state bank only speaks to authorized dealers. So you go to your bank will help you, number one, send that remittance abroad under this scheme. And number two, your bank will help you then after you have set up your holding company, you have to report it to the state bank. And that also happens through the bank. So you submit all your documentation, say I have proving that you have complied with this law, and you submit all of that documentation to your bank, and then your bank will submit it to the state bank of Pakistan.
सॉरी मुबारिज तो पार्सल में रहते हैं काफी सवाल
हाँ।
जो आपने बात की है ना बैंक तो एक सिंपल अकाउंट खोलने के लिए कोई इतना मसला हो रहा है आजकल और ये जो कि मुझे नहीं पता आपको ज्यादा पता है ये बताएं कौन सा बैंक है ऐसा यहाँ पे कौन सी वो ब्रांच है जिसको इस सब बातों का पता है और ये सब कर देगा हमारे लिए
So what we are doing with State Bank, and this is exactly why we had a conversation with senior management leadership at State Bank. We are having sessions with different banks which will have presence of startups, which will have presence of lawyers like myself, VCs and State Bank to make them aware of what these regulations are, to make them aware of what kind of transactions will take place and how to handle them. It will take some time because ये रेगुलेशन फरवरी में आई है पहली बार पाकिस्तान में, तो बैंक्स को इसमें कस्टम होने में भी थोड़ा टाइम लगेगा. बट typically incorporating a company abroad is now fairly cheap. It's not very expensive. You could do it on your personal credit card, really, and you could just incorporate that holding company. And the other thing is you are only opening a holding company when you're raising capital from abroad. When you're raising capital from abroad, I hope you would only go out and incorporate the company once at least your term sheet is signed and you are somewhere through the SHA phase. After that point, the investors would also be willing to, जो investors जो बाहर बैठे हैं, they would be willing to take the upfront cost and help you establish the holding company and then send that. And a lot of lawyers, if it's a bigger round, a lot of lawyers are willing to defer their payment till you raise and then you can pay through the holding company after you've raised the capital there. So वो सारी चीज़ें sequencing possible है, but you've identified the problem correctly कि यहाँ पे बहुत सारे banks को नहीं पता, but वो जो knowledge gap है उसको bridge कर रहे हैं अभी.
So is there any branch manager in Karachi?
You could go to Bank Al-Falah. I'm personally working with Bank Al-Falah to solve this as well. We can take this offline and I can tell you as well. Maybe 10 more minutes. Yeah.
Specific way.
Yeah. I know. No, I'm good. ये मांग रहे थे.
Maybe slightly off topic, but since we were talking about raising capital now, one of the issues that I was trying to find out was, are there any escrow services available? I know Telenor was planning since the last 3 years, 4 years, but somehow never launched it. Is there any other service?
I am not, actually, it's a good question. I'm not very familiar with one, but I'm sure most banks can offer you trustee services. Their license enables them to do it.
Like for a startup, when we're dealing with our customers, there are certain things which are not like 2,500 वाली चीजें नहीं है महंगी. वहाँ पे आपको escrow चाहिए होता है ताकि ना client का trustee हो आपके लिए भी.
आपको वो जो बैंक देगा वो escrow सस्ता तो नहीं होगा, for sure. It may not work for smaller transactions, but maybe if you're selling houses type of thing, yeah, I'm sure if you go to a bank and ask them for specific escrow service and escrow account service, they would be able to offer it to you.
Most of the banks are.
Not most of the banks. I can have to find out and I can tell you exactly which bank, but I'm sure banks are allowed to do the service. So I'll have to check which ones are actually doing it.
I'll be really grateful.
Sure, definitely. उनका एक class. Yeah.
Just on the escrow, I think DeFi will solve that, but that's not my question. How important
yeah.
is it to have a legal rep on your board as a startup?
It's not important at all. Why would you need a legal rep on your board?
So you don't think it's important to have any sort of legal rep from your board just to guide you through navigate people?
Depending on what you're doing, if what you're doing is a heavily regulated activity, I really can't think of an activity which would absolutely require you to have a legal presence on your board. You could always engage a lawyer. You could always consult lawyers on different aspects of your business, but I can't think of any unless it's a legal tech type startup, etc., which may need you to have a lawyer on board. I can't think of any service or any product which would absolutely require you to have legal presence on or presence of a lawyer. No, no, I would rather add value beyond being a lawyer. Yeah. Anyway, I think that's.
So, okay, so what should be the agreement? Where does the share go?
It should be based on time. Say if two co-founders start 50-50, it should be based on कि अगर 5 साल बाद या अगर 6 महीने बाद हुआ तो you lose majority of your shareholding. But अगर 4.5 साल बाद हुआ तो you lose less, right? Etc. In either way, in case of death, I would say there should be some sort of payout if the business is making money, or there should be some sort of promise to pay whoever the successors or assigns are, that they would get this kind of money in return. टिपिकली होता यह है कि शेयर्स कंपनी बाय बैक कर लेती है और उसकी जगह कंपनी अगर उसके पास कैश होता है या इन्वेस्टर्स के पास कैश होता है दे डू इट बिकॉज द आइडिया इज इन एन अर्ली स्टेज बिजनेस the founders would want the bet is on the founders, and you want the equity to be with the founders, and it's the founders who are working constantly for that equity. Now, if a founder is not there for reasons such as death, I would say there should be some sort of payout or a promise for a future payout at a fair value, but that equity then should be reassigned to somebody else who will be putting that time in.
So can it be like if they have a share and they die, payout can go to their successor?
Yeah, whatever you guys think is the nature of the business, right? अगर business monthly basis पे cash flows आते हैं उसके पास और बहुत ज़्यादा cash एक साथ नहीं होता, तो then yeah, pay out monthly for a certain period of time. You can put it whatever you feel is fair and however you want to do it. There's no hard and fast rule around it. Thank you. Is that it? Wow, we're done. Wonderful. Thanks a lot, guys. Thank you very much. If you have any other questions, feel free to reach out via email or social media, whatever. I'd be happy to assist. Thank you very much.
Platform, you're requested to get feedback on
Mhm.
session.
मैं भी आता हूँ. Sorry, हाँ मैं इसको बता देता हूँ.
Can we do a picture, please?
Good job. Sorry.
Your tip is not supposed to be.
Yeah, I know. I was very.